Hey, what's up, everybody? It's Stephen A. Williams, president and founder of thecreditrepairshop.com. And in today's video, I'm going to talk about debt collector calls, what is considered harassing, oppressive, or abusive conduct. It may not be exactly what you think, and you might be a victim of harassing or oppressive or abusive conduct by a debt collector and didn't even know about it. I'm going to give you an example that is straight from the CFPB, so you will know that if something like this has happened to you. I do have to let you know that you have to document this stuff. Even if you end up taking them to court, you're going to have documentation. Now, what most attorneys will do that deal with this type of stuff against debt collectors is that they will subpoena their phone records so they can see how many times an individual was called. And also, this is a video. This video is, in a sense, a more of a breakdown of what yesterday's video was about, which was you don't have to pay a debt if they violate certain rules in the FDCPA, the Fair Debt Collections Practices Act. And but I wanted to make additional videos that would break down one of the sections that was within that video. So if you haven't watched that one, type in the search on my channel, Don't Pay Debt Collectors, and you'll see the newest video that I've made. I've made several with that, but that was an updated one that went down a list of things that debt collectors have to abide by to be able to continue trying to collect debt from you. And these are debt collectors who buy debt. Also, I wanted to clarify from yesterday that with the letters, like I had a long list of violations, and something that I didn't clarify was that we already do that for our clients. So if you are a client of the Credit Repair Shop, all you'd have to do is send us a letter, and my staff already knows to do what I talked about in that video. And if you're not a client of the Credit Repair Shop and you don't really need full credit repair services, we do offer a service where we can make that particular violation letter to that debt collector to get them to stop coming after you potentially. You know, they probably, it's sometimes some back and forth because they might say we have something that you didn't have. Or that you maybe didn't get because it was mailed to the wrong address or something like that. But that letter really does do the job. So let's get into it. So Section 1006.14 of and this is on the Consumer Financial Protections Bureau website, and this is subsections or subparts of the Fair Debt Collection Practices Act. These were additional amendments, so to speak, that they put in their regulations. And one of them is 1006.14, harassing, oppressive, or abusive conduct. Now, you might be saying, well, if the lay person, when you think about harassing, oppressive, or abusive conduct, maybe you can identify a harassing debt collector. That's if they're calling you over and over. Oppressive, you may be wondering, okay, what would define oppressive behavior by a debt collector? And then abusive conduct, you could probably understand what abusive conduct would be. Now, just so you know, they put these words in there for a reason. They don't, they could have just said, well, harassing telephone calls from a debt collector. But no, they put this in there because they want, with definitions, this is something that I've learned with dealing with a lot of court cases, dealing with myself or dealing with individuals where they were being sued by debt collectors. These terms and words that are utilized in these in either laws that are made by our government, or if you're being sued, they'll use certain terms. These terms are put in there for a reason. It's just not because someone was just like, let me go pick a word and throw it in there. So dealing with with harassing, oppressive, and abusive conduct, let's just start here at the top here. It says here, in general, a debt collector must not engage in any conduct the natural consequences of which is to harass, oppress, or abuse any person in connection with the collection of a debt, including but not limited to the conduct described in paragraph B through H of this section. Now, let's talk about B real quick. In section B, repeated or continuous telephone calls or telephone conversations. So they're already kind of establishing that if a debt collector calls and you tell them, hey, I cannot afford to pay this, and they continue to call you and call you and call you, and you've already had a conversation about that, that could be considered harassing conduct. That could be considered abusive conduct, and depending on what they say, could be considered oppressive conduct. So now let's get into it here on what it says here on B. It says here, number one, and what they do is they say an official interpretation. So I like this. What they're trying to do is to give the public examples of what they would consider harassing, oppressive, or abusive. So let's read it right here. This is not my words. This is directly from the CFPB. It says here, official interpretation of 14B. Repeated or continuous telephone calls or telephone conversations. Key word, telephone calls or telephone conversations. Placing telephone calls repeatedly or continuously. Section 1006.14B prohibits a debt collector from, in connection with the collection of a debt, placing telephone calls or engaging any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass any person at the called number. And it continues, and it describes when a debt collector is presumed to have complied with or violated that prohibition. So when we kind of get into that, like dig into it, I'm going to say the part again that I believe that you need to pay attention to, because this could be actually happening to you. A debt collector placing telephone calls or engaging any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass any person at the called number. And it also says, now look, I'll say that part again at the end, any person at the called number. So have you ever had the situation where someone answered the phone and it was a debt collector, and they asked for the person who they're looking for, but because that individual answered the phone, they would say, well, we don't believe you, or I know that they're there, or I can hear them in the background. It could be, they could say anything. I mean, if you have a debt collector calling you, you know that they will say things like that. I remember when I had a debt collector calling when I was in the 1990s. They used to call the telephone. We didn't have cell phones at that time, and they would call the house, and either my wife would answer or I would answer, and they would say things like this. This stuff here was probably not as defined back then, as it is now, but it is they've kind of laid it out to have interpretation, because this is what the problem was in the past, is that debt collector could say, well, we just didn't know, we didn't know that asking someone else the question would be considered harassing. We thought that only if we talked to the individual that we're trying to talk to and we repeatedly asked them questions, that would be the thing. Now, something else that has been added in my state, I talked about this yesterday, they cannot even talk to another individual they can only ask, are you there? And then if not, hang up the phone, cell phone or landline. In other states, it's kind of gray, but federally, they just can ask, and they can go a little bit. It's a gray area, but they can ask, have you talked to them? Is this the number to reach them? Like, you can't even ask those types of questions in my state anymore, but other states, they have a little bit more of a gray area. Now, federally, they could, and a debt collector could probably, come into our state and say, well, we don't believe it was a violation because federally the Fair Debt Collection Practices Act allows us to ask those questions. But in our state, this is the way that they come back with it, is that if you want to collect debt in our state, and you have to be licensed to collect debt in our state, when you get licensed, you have to go under our state laws for debt collection. So they would just boot that debt collector from being able to collect debt in our state. Other states might have a little bit different. So I'm going to repeat it again. This is the official interpretation, 14B, repeated or continuous telephone calls or telephone conversations. Placing telephone calls or repeatedly or continuously. Section 1006.14B prohibits a debt collector from, in connection with the collection of a debt, placing telephone calls or engaging any person in telephone conversations repeatedly or continuously with intent to annoy, abuse, or harass any person at the called number. Any person at the called number, repeatedly calling, maybe saying things like, we know that they're there, why don't you give us more information? Have you been giving them our information or call us back? They can't do none of that stuff. They cannot do that stuff. And then if your state may have additional laws on even more things that they cannot do. Like in my state of Wisconsin, all they can do is ask for the person. If the person is not there, that's it. They can't say, well, when will they be there? Or what's the best time to call? None of that. They cannot ask unless that person is a co-borrower on that loan, on that debt. They cannot ask any additional questions. That is key. That is key. Now, let's go into official interpretation. It says here, in general, in connection with the collection of a debt collector must not place telephone calls or engage any person in telephone conversation repeatedly, continuously, with intent to annoy, abuse, or harass any person at the call number. Now, official interpretation of that. Here's the compliance. Effect of compliance. A debt collector who complies with 1006.14, which we just read there, and the FDCPA 8065, 15 USC 1692D5 complies with those two. Solely with respect to the frequency of its telephone calls, the debt collector nevertheless could violate 1006.14 and FDC Section 806 if the natural consequences of another aspect of the debt collector's telephone calls unrelated to frequency is to harass, oppress, or abuse any person in connection with the collection of a debt. Now, I'm about to show you what that means. That goes into how many times they'll try to call a person over and over and over, if they get them on the phone or not get them on the phone. So now here, they gave an example, official interpretation. They gave an example. Assume that a debt collector communicates or attempts to communicate with a consumer about a particular debt only by telephone. The debt collector does not exceed either of the telephone call frequencies described, which would be 7, under 1006.14B2I. The debt collector is presumed to comply with, and then they repeat it again. Assume further, no evidence is offered to rebut that presumption of compliance. That means that you don't have any of your phone records to say, hey, you called me more than 7 times in a week. Or that's basically what it comes down to. That's going to be the evidence that they would use. So, continuing, the debt collector complies with 1006.14 and FDCPA 806, which is all about the compliance with harassing and all that stuff, but only with respect to the frequency of its telephone calls. Assume, however, that one of the debt collector's telephone calls results in the debt collector leaving a voicemail that contains obscene language, even though the debt collector does not violate the frequency, but they violate leaving some type of harassing message like, why haven't you called us? We've called you several times. We're going to end up calling your job. We're going to end up suing you, whatever. And it also goes into if they say something obscene. I don't think any debt collector that is truly in the business is going to say anything obscene. It's going to be more of skirting by saying stuff like, when are you going to call us? Or they might, I've heard deadbeat be used, or why don't you pay your bills, saying words like that. Now, let's get into this call, attempts to call. So this is an official interpretation presumption of compliance example. So it says here, on Wednesday, April 1st, a debt collector first attempts to communicate with the consumer in connection with the collection of a credit card debt by placing a telephone call and leaving a limited content message. Between Thursday, April 2nd and Tuesday, April 7th, the debt collector places 6 more telephone calls to the consumer about the debt, which of all go unanswered. As of Tuesday, April 7th, the debt collector has placed 7 telephone calls to the consumer in connection with the collection of a credit card debt within the period of 7 consecutive days that started on Wednesday, April 1st. Assume the debt collector does not place any additional telephone calls about the debt until April 8th under 1006.14B2I. The debt collector is presumed to comply with that section, and also under the FDCPA 8065. Now, let's go into the next one under the official interpretation. On Thursday, August 13th, a consumer places a telephone call to and initiates a telephone conversation with a debt collector regarding a particular debt. Assume that the debt collector does not place a telephone call to the consumer in connection with the collection of the debt again prior to Thursday, August 20th. The debt collector is presumed to have complied with the 1006.14 and FDCPA. On Tuesday, October 6th, debt collector first attempts to communicate with a particular third party for the purposes of acquiring location information about consumer by placing a telephone call to that third party. The call is unanswered. The debt collector places up to 6 unanswered telephone calls to that third party for the purposes of acquiring location information about the consumer through Monday, October 2nd. The debt collector is presumed to comply with, and again, it repeated again. For further guidance concerning when the debt collector is prohibited from communicating with a person other than the consumer for the purposes of acquiring location information. All right, so now let's go into what the CFPB would consider your evidence to rebut if a debt collector has made too many calls over a 7-day period. And from my understanding too is that if a debt collector calls to try to get location information, and remember, they can't do that in my state, but if they're doing that in your state and it doesn't have the same rule that we have, that is still considered a contact. Even if they don't get in contact, leave a message, that is still considered a contact. So let's look at what it says here. Factors to rebut the presumption of compliance, because all of that is about if the debt collector complied. So to rebut the presumption of compliance, it must be proven that a debt collector who did not place a telephone call in excess of either of the telephone call frequencies as described in 1006.14B2I, you can look that up, nevertheless placed a telephone call or engaged a person in a telephone conversation repeatedly or continuously with the intent to annoy, abuse, harass any person with the called number. Any person with the called number. If they're calling, what's that location? Tell me where they're at. We just trying to get in touch with them. All of those types of things. For the purposes of determining whether the presumption of compliance has been rebutted, it is assumed that a debt collector intends the natural consequences of their action. So that means that even if you have information that shows that they could potentially be out of compliance, the debt collection company has a responsibility due to the laws that they are under for the Fair Debt Collection Practices Act and under the CFPB Section 1006.14. It says here that for the purposes of determining whether the presumption of compliance has been rebutted, it is assumed that a debt collector intends the natural consequences of their actions. Comments 14B2I2 through and that's I is and then V4 provide a non-exhaustive list of factors that may rebut the presumption of compliance, and we'll get to that in a second. The factors may consider either individually or combination with one another or other non-specified factors. The factors may be viewed in light of any other relevant facts and circumstances, therefore may apply to varying degrees. Factors that may rebut the presumption of compliance included. Okay, so to go into more detail about the compliance, the thing, what you need to be aware of to make sure that they did comply with you is that basically you're going to have to really do your homework or take notes, really just take notes. And you would have to look at if they contacted you by email, if they contacted you by phone, if they contacted you by doing messaging, if they contacted any of your references. Basically, you're going to have to see and compile all of the different ways that they tried to contact you. And if it was over 7 times over a 7-day period. And then one of the gray areas when I was reading through this that is not quite clear is that if you speak to a debt collector, and it doesn't clarify it here, but in the Fair Debt Collection Practices Act, it kind of clarifies a little bit, but it's still a little gray. If you speak to a debt collector and you tell them that you cannot pay on that debt, that you're just not able to do it, from my understanding from the way that things were done in the past is that the debt collector will call you each month and just to be like, how is it going now? Are you able to pay now? You know, just trying to keep the communications open. It looks like what is allowed now is that they could call you every 7 days. Every 7 days, when you've communicated with them and told them that you will not be able to pay the debt, that you're just having financial hardship, that they can still call you after 7 days on that. So if they're not getting in touch with you, they have a maximum of 7 attempts. That could be a combination of email, phone, landline phone, calling your references. All of that counts in that 7 day or 7 contact package, 7 consecutive days. But the gray area is if you say to them, I don't know if I could pay this, or I'm not going to be able to pay it right now. And you're just leaving the communications open, and you don't even have to attest to the debt. You just say, send me what you got, validate it. If it's something that you know is yours, you're going to have to end up paying it or doing a settlement, but you don't have the money. Money is just not right now. You just tell them, hey, I'm not able to pay it. And then they're not supposed to just keep calling you consecutive because you've already communicated that to them. But it looks like what they can do is that they can call you after 7 days. On the 8th day, they can call you again. Hey, anything changed? Whatever. Back before in the past, even with some debt collectors, depending on which ones now, they would usually just call once a month. Like we've managed some accounts for clients in, like American Express or Bank of America, any of those. And those companies would call like once a month. They would just say, anything changed with your client? Are they able to do a settlement, able to make payments or whatever? But they would just do it once a month. So, some of this stuff may have kind of, things might be changing where they're giving a little bit more leeway to debt collectors and also putting a little bit more restrictions on them. And but bottom line, when it comes to communication from a debt collector, bottom line, you're going to have to take notes on how many times that they communicate, because the number one way is that they're going to want proof on that they violated. Now, your two options, here are your two options. If you get an attorney, there's attorneys that will do this. If most of them would like to get some sort, they would like to get proof. Some of them will, if they believe what you told them, they would, contact the debt collection company and let them know that there is a violation, and they would, try to work out a settlement with them. If you're doing this yourself and you just are good with them ceasing to come after you for the debt, you could just notify them that you believe that there was a violation, and you can put, just in writing the days that you believed over that period of time that they violated. Or even if they didn't go over that amount of time of calling, that it could have been the words that were used, and if you kept your voicemail, or if they communicated with another individual and that individual was willing to say that they would sign an affidavit stating that that debt collection representative did go outside of the bounds, that would help you with getting them to either just cease all collection activities, or if you wanted to push it, maybe you could push to try to get some sort of a settlement for them doing a violation. The violations could be anywhere between $500 to $1,500 per violation when it comes to debt collectors. The other thing that you still, no matter what, you should always keep this in mind, because I don't want to get people confused where people are saying, Steve, you're saying one thing at one time, one thing another time. My assumption, just like the CFPB and Fair Debt Collection Practices Act, my assumption is that you've already done some sort of debt validation, and you're just like into the into dealing with the debt. Not that you've gotten a dunning letter and you've responded and you've done everything that I tell you to do when you first make a contact with a debt collector. This is continuing things, or it could be at the beginning when they're just trying to hunt you down or they're trying to get you on the phone. This could be at that beginning process, but I still say that when you're dealing with a debt collector and you have not received any documentation, that is technically a violation. They might try to say, well, we didn't have your correct location. We did mail it and it came back to us. That's something that they would try to say, and they probably would keep that they tried to mail it to your previous address, which would protect them from violating that they did not give you a chance to dispute the debt. But if they call you and you tell them, hey, send me what you got, they ask for your new address, that's going to be up to you to give them your new address. If you're going to deal with it, if the goal is to deal with this stuff so you can let your credit move up, then you have to give them your new address. You get that information. Make sure that letter is appropriate. You can look at my videos on that's called a dunning letter. There's certain things that have to be on there. Number one, they have to allow you the chance to dispute it. The font sizes must be the same. They have to identify who they got the debt from, the original creditor, identify themselves, put their reference number, file number, and they put the last four digits of the account that you have with the original creditor. And all of that has to be same size fonts. Like, it can't be tricking you. They can't leave out that you have a right to dispute any or all of it. Not just say you have a right to dispute. That you can dispute part of it. You can dispute all of it. You have that right. So you get that letter and you do that first, and then you can go with the back and forth, and they're going to obviously start calling you if they pass the dispute process and they believe that they have enough information to prove that you have to pay the debt. Then they're going to pass that, and then they're going to start calling you about it. They're going to start going into what we basically just went into right here. All right, if you need help with your credit, please visit us at creditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters, statute of limitations. For debt that's past the legal statute of limitations to collect, you do not need to do a debt validation when you get those. Cease and desist collection activities letter, and that's what you can use to potentially stop a debt collector, because there's certain documents, certain things that they must do in their office to prove that they can collect that debt from you. And if they do get that information, I give you a debt validation so you can go back and forth with them to stop them from collecting on that debt, or to get you into a good settlement position to where you can do a settlement and resolve it and move forward with your life and help and start rebuilding your credit. Please like this video. Please subscribe to the channel. Post your questions and